Hi everyone, and welcome to another episode of Let's Talk Risk with Dr. Naveen Agarwal. Each week, we talk about a topic related to risk management of medical devices in a very casual and informal way. This is not a webinar or lecture. Rather, our goal is to talk about key topics and challenges in a very informal way and share best practices. I'm your host, Naveen Agarwal, and I'm the principal and founder at Achieve, where my personal mission is to help you achieve success in risk management. My guest in this episode is Neil D. Spirito. Neil is a life sciences attorney for pharmaceutical, biologics, and medical device law, regulatory, commercial, and FDA enforcement defense. But he also has tremendous amount of industry experience as a business leader in the pharmaceutical organizations. In this conversation, we are focusing on the legal implications of the upcoming Quality Management System regulation and its harmonization with ISO 13485. We had this conversation in front of a live audience as part of our weekly LinkedIn live audio series. You're about to hear a recording of our conversation. So sit back, relax, and enjoy the show. Hi everyone, and welcome to our weekly Let's Talk Risk conversation. Great to be with you again. Today my guest is Neil D. Spirito. Today, guys, we're going to talk about QMSR and ISO 13485 and all the legal aspects of it. Because Neil is actually an attorney. So,
hello, Naveen.
Oh, Neil, you made it. Great. How are you?
I made it. How are you?
I can hear you. I can hear you fine. So thanks for joining me. So I was just welcoming our audience today. Guys, you are in for a treat because Neil has experience in the industry and also he's an attorney. So we can have a lot of conversation and discussion about the legal aspects of QMSR and ISO 13485. We know it's coming, right? In less than 2 years now, February of 2026, we are supposed to start complying with QMSR. What does that mean and what are the implications? So Neil, I would like to just first welcome you to our event here. And by the way, this is a very informal conversation. And all of you are welcome to connect with Neil on a one-on-one basis if you want to have more direct conversation with him. But we will just talk about ISO 13485 and QMSR in general. So Neil, welcome. How are you today?
Well, thank you, and thank you for having me on today, Naveen. I appreciate it.
Great, Neil. So first, let's start just by introducing yourself to the audience, and in particular, I'm very interested to hear how you transitioned into the legal profession from your industry side where you had executive roles and you had P&L responsibilities. So you were like in business. How did you get into the legal profession?
Okay, well, out of college, I wasn't really sure what to do. I was a science major and I didn't really know what I wanted to do. So I went on an interview for the old Upjohn company and they said, we can probably use you. And in those days, they had the executive training programs, and they rotated me through regulatory and quality and compliance and manufacturing and marketing and all of the different things. And they sent me for my MBA on nights and weekends. And I progressed through the company up to the point where I was running my own division, my own business. Most recently, I had one time had Europe, and then most recently I was managing director of Asia Pacific. And then at the end, when the company merged with Pfizer, I also had Latin America in there, but it was mostly Asia Pacific. And then I had gone for my MBA, I had gone to law school, and I decided that someone near the science and the business and the law, they would do much better. I felt that there was a gap there, that many of the attorneys didn't understand one part or the other. Obviously, they understood the law, but not the business or the legal or the science. Mm-hmm. So that's how I basically got involved. And then I think it was 2000 or so, Pfizer bought us out, and I had had enough of corporate mergers. So I went out into private practice, and I was a government prosecutor for a while. And then after a few years, I left there and went into private practice in big law. And at that point, then I went to the boutiques, and recently I opened my own shop. So that was pretty much the progression through there.
This is fascinating, Neil. I think you have seen the industry. You have been in a business role, and now through private practice, practicing law, and now your own consulting practice, focusing on life sciences, right? It is fascinating.
Absolutely. And most of my practice in the early days, when I first went into private practice, was enforcement defense, because I had tried the cases as a prosecutor. And so I was doing a lot of enforcement defense. So I saw how all these things become problems. Okay. And then it rotated into litigation and more transactions, licensing and licensing out, those type of things, mergers and acts, making sure that everything was in compliance with FDA, and then on to pretty much what I do today, advice and counsel, where I try to keep you out of problems with the FDA, although I still take on enforcement defense activities, especially after a warning letter or replies from different questions from the government, etc. So that's a lot of where I'm working these days.
Perfect. Thank you, Neil. So let's talk about QMSR. You know, FDA is transitioning into QMSR, and they expect industry to comply beginning February 2026. So in your opinion, first of all, how is that going to play out from a timing perspective? Like, people are supposed to comply with QSR until then, and then after that QMSR. So is that like a flip of a switch? How is that going to work?
Technically, it's a flip of a switch, but government never makes a really smooth transition. I mean, they have to move away from the current QSIT system and into the new inspection system. They have to train the investigators. They have to train the staff. They have to, they have to comply with many of the new requirements, because not only are they changing the regulation, but they have other requirements as far as training and managing the new requirements, the new inspection protocols, things in those areas. But you need to be ready, because they may apply some discretion, but technically, the minute after it goes into effect, you are bound to the QMSR. And that brings up an interesting point, because the QMSR, is a modification of the old 21 CFR 820. And what happened in 21 CFR 820 is that although it's not technically a law, it has the weight of law. So let's digress a minute and let's start. First, there's the Act, which overall empowers to do what they do specifically. Then, under the Act, and obviously the device amendments of 1976, and what then happens is parts of the Act are codified in the United States Code, USC. That's why you see references to the Act and different numbers that are referenced as USC. That's where they take pieces of the Act and codify it. That's statutory law. Then they, from there, promulgate regulations. And they promulgate regulations under what's called the Administrative Practices Act. And that's a separate act. But what that does is that applies. It doesn't matter what agency you are, if you're the Department of Justice, if you're the SEC, if you're the FTC, everybody has to make their rules in compliance with the Administrative Practices Act. Okay? So Now what happens is they take 21 CFR 820 and they modify it. They say that was the old QSR, we used to call it.
Yeah.
Now, the old QSR, what we're going to do, because it's very cumbersome for manufacturers to have one set of regulations for us and one set of regulations for EU, Canada, Australia, and the rest of the world.
Mm-hmm.
So what we're going to do is we're going to take certain parts of 13485 and we're going to make them part of 21 CFR 820, what they call integration by reference.
Yes.
So they're referencing these particular parts. What's the significance there? The significance is it takes something that's an international standard that doesn't have any weight of law, and it makes it now makes it have weight of law. So even though the Code of Federal Regulations aren't technically laws, they have the weight of law, and you can be punished for violating them just like you can for violating a law.
Yeah. Yeah.
Okay. So that's the key as to what's happening there. And, you know, one of the things that's important is all of this has to comply with the Act. So in other words, you see the Supreme Court all the time. They're judging things by the Act and by the Constitution. Okay, so in other words, does the Constitution allow it? So when FDA takes American manufacturers to court to task criminal charges, civil charges, whatever, an American manufacturer has due process.
Yeah.
So that always has to be established. Nothing the agency can do can impinge upon that due process.
Right.
Okay.
Right.
So that's what they're looking for. And so, you know, they're reviewing, the court's review for the rules and regulations complying with the Act and the Constitution. Now, when you come down, and this is a key thing, the regulations this is by other legal principles, but all the law students learn, and then when you get out in practice, you see this in actuality.
Mm-hmm.
Everybody learns that the actual implementation of this becomes, from a practical type of standard, okay? So what they can't do is they can't be overbroad.
Yeah.
Can't be overburdensome. So that's what is always the key, that you have to have a narrow regulation, and the narrow regulation, in fact, prevents overbroad interpretation or overbroad actions by the agency.
Yeah.
What happened here is, it was very simple. The manufacturer said, you're overly burdensome. We have one set of regulations for you, one set of regulations for Europe, for the world. You know, they're going by ISO. You're not going by ISO.
Yeah.
So the agency, to maintain the fact that they're narrow in their regulation and they're not overly broad, then decided that, you know, these need to be integrated as much as possible.
Yeah.
Now, the key thing here to understand is that not all of ISO 13485 is included, okay, by reference. A lot of sections are. And Vince Gafeso on LinkedIn did a whole series about where there's differentiation.
Yeah.
And that's normal in an early law because there hasn't been any ADJ, administrative law proceedings, or FDA hearings, or federal district court hearings that have made rulings on, you know, these conflicting terms.
Yeah.
So that will happen over time.
Yeah.
But I don't want anybody to be comfortable in saying, oh, I followed ISO to the letter. It doesn't matter. You have to follow 21 CFR 820. And that's the key to staying out of trouble in this. And if there are conflicts, that's where your lawyers come in.
Got you.
Obviously, your consultants like yourself, Naveen, work on the technical areas of this. How do you do certain things? You interface with the FDA technical people. How is this done? Why does this comply from a technical standpoint, et cetera?
Yeah.
Where we get these conflicts, where we have these other issues in law, that's where the FDA lawyers come in.
Yeah. That's great. Great point, Neil. So I know our audience probably has a lot of questions and thoughts on this. So I think I'm going to start opening up our discussion. Guys, you know how it works. Please just indicate to me that you would like to join us and be a part of this conversation. And again, it doesn't have to be a question. It can be your own perspective or insight. What are you concerned about? How are you approaching QMSR transition? All of that is relevant. So just please indicate your interest and I'll bring you up on stage here. So Neil, as we wait for folks to join us, do you have any quick recommendations or suggestions in terms of how the manufacturers should prepare for this transition?
Manufacturers should be taking the new rule, 21 CFR 820, and they should be applying it to their current operations. What they should basically be doing is going through their current QSR, comparing it to the new QMSR, and making sure that any changes are implemented. Mm-hmm. Now, when they get to areas where they say conflict or are very different or they don't believe it was intended by the FDA, that's when they check with me or their FDA lawyer, because that's where we have to get clarification as to what exactly the regulation is.
Got you. So, but one thing I want to clarify with you for my understanding, I think the manufacturers can look into the differences and gaps and whatnot and prepare for it, but they're not supposed to implement them until February 2026. Is that right?
Well, here's the thing. When you implement it, okay, so you're going to implement this, and they've given you a number of years to implement it. So what they're doing is they're saying during this period we have discretion. So we're not going to get you in trouble for not implementing it, okay? So you have to be with the QSR. The actual practical problem, and you point out a very good practical problem, and that is that the inspectors or the investigators won't be trained in the QMSR until that time.
Yeah.
So they'll still be going by QSR. So that's the actual problem. So you want to be all set to implement it. And I always recommend running parallel systems. And I know you, Naveen, and a lot of the really good consultants recommend parallel systems. So those last 3 months before it happens, they should be running parallel systems to make sure that there's a consistency, and when they switch over, there's no problem.
Yeah, that's a great point, Neil. And what I have sort of shared with people based on my prior experience is that whenever you have big changes coming like this, leverage a quality plan, make a quality plan, put it in place, and declare what your intentions are, what your timelines are, what your deliverables are, so that there's no confusion. And even if you are, let's say, halfway there, you can tell them, look, this is our work in progress. This is what we are doing. So quality plan. Great. I'm going to try to get Chris and Bijan here, who are requesting to speak here. Chris, you are on. So go ahead. Please unmute your mic and share what you have in mind.
Hey, good morning, Naveen. Good morning, Neil. These last few points that you've made, Naveen, are interesting because these are sort of topics that came across my mind when the QMSR was first announced. And, I'm wondering for organizations that are already following 13485, which is the QMSR is pretty much will be based on, is that if you're also following QSR, which you would currently be if you're selling in the US, if you are complying with one, you're not necessarily conflicting with the other, even if the requirements are different. So, for example, if there's an additional labeling requirement for one that doesn't appear in the other, it doesn't necessarily conflict with the first one. So the idea of having the parallel systems going on, in my mind, doesn't automatically create a conflict. So I'd be interested to learn a little bit more about whether it specifically is something that we'll be worried about.
Here's the thing. If you're in the U.S., even to be compliant with QMSR, you don't have to be ISO certified, 13485. Now, if you're in Australia or Canada or the EU or other countries, you do have to be ISO 13485 qualified, certified. But so that's where I think some of the confusion may come in on this. But I will say this. If you're adding 13485 to the current regulation, okay, in most instances, you're absolutely correct. You're going to have additional information, but it's not going to conflict. There's some certain things, especially in definitions and some of the other places where we see some conflict, okay? But I don't think that's anything to worry about in your parallel systems. You're judged on your QSR, and then, when this transitions, you're where you are. And I'm sure the inspectors have been told to give people a grace period as they're coming up to the actual date itself.
Got you. Okay, so let's keep moving, guys. So, Christine, I'm going to invite you now to unmute your mic and share what you have in mind.
Hi, thanks for the opportunity. I think where my mind goes on this is wondering how this transition is going to apply for manufacturers participating in the MDSAP program. I'll just start with that.
That's a good question. That's a good question. And, I don't know that we have an answer on that yet as to particularly how it's going to. Generally, things have to be consistent. So FDA would need to, in an instance, to unify these or harmonize these, because again, the whole idea of this is not to be overbroad legally. So whenever you have something that creates an overbroad situation, the FDA has to narrow it, make it the least burdensome, is particularly the legal jargon. So I don't know that there's an answer to your question yet, but I'm sure there will be by implementation day.
Mm-hmm.
So what I think, can I ask a follow-on question?
Sure, please, go ahead.
Is that right?
Mm-hmm.
Okay. So, when they published 1345 2016, there was an adoption process that happened for Europe, right? And it became a harmonized standard, right? And part of that was the creation of annexes. So now we have, Annex ZA, ZB, and ZC. And within this, there's correlation between the European at that time directive, right, now regulation, and the elements of the standard, right? So I guess I'm expecting that we're going to get to see new annexes. So we're all going to get this much larger version of the standard that incorporates both, the European annexes and then the FDA annexes. Is there anybody have any insight on where that's heading, or if that's even in process?
Okay. Let me say two things. First of all, the MDSAP is more stringent requirements of the two between ISO 13485. MDSAP is more stringent. So you're in compliance there. Okay. So you may you do a comparison to QMSR. But your single audit program is something that's entirely different from, it's going to be something that's entirely different from your QMSR type obligations. And how they rectify that, we're not sure. Europe did give a discretionary period, as you said, a phased in. I wouldn't be surprised to see that here in the U.S. But the point of law here in the whole thing is that FDA did not say that any changes, transition, annexes would be included in 21 CFR 820. what they did say is that every time a change occurs, they're going to have to look at it as to whether they include it.
Yeah.
And the Administrative Practices Act is going to require that they do all the things to make changes to the promulgated rule that they have to, including comment periods and everything else.
Yeah.
So I wouldn't expect that as things change, as there's annexes, as there's these different type of things, that they would immediately be in 21 CFR 820.
Yeah.
That, this has to be approved.
Yeah.
And
you're going to have a transition period, then you're going to have enforcement discretion.
Yeah.
And, who knows? Hopefully they'll do a better job than Europe's been doing with implementation. But
Got you. Looks like, Ed, you are trying to say something. Please go on. Go ahead, Ed, please. Go ahead. Okay, Ed. All right, no problem. So, okay, let's keep on moving, guys. I know, Bijan, you have been waiting, so I appreciate your patience. Please go ahead and share what you have in mind.
Hi, Naveen. And hi, Neil. Thanks for your speech. I'm interested in a little bit more about the law part, and this is about the mechanics of the law. You mentioned the U.S. Constitution, then beneath that we have acts, beneath that we have U.S. Code, United States Code, and beneath that we have regulations. Is that the correct progression first?
yes.
Okay. And then the next part of the question is that what part is actually enforceable? Is it the regulation part at the bottom, or is it the Constitution? What is the enforceable part of this hierarchy?
The whole thing is enforceable. So, in other words, the promulgated rule is the specifics. That basically says Congress told us to act. They created an act and it said, the old 505B1, 505B2, you have to have this system. Okay, we took parts of that and we codified it as law. And now, to make it practical so that people can implement it on an everyday, we promulgated a regulation. So you have the regulation there. So what in essence is happening here is you're a manufacturer. You do what you have to do according to the regulation. But that's not enough because there are interpretations of the regulation by the courts. There are interpretations of the regulation by the agency. A big part of this is going to play into that whole Chevron piece that's pending right now, the case that's going to determine the Chevron doctrine, which basically gives deference to the agencies, which John Roberts, in an opinion, I can't remember if it was last year or earlier this year, it was last year, basically said the courts are applying it too often. There's a whole set of legal tests that you have to use before you can send this back to the agency. Now what they're determining is, should the agency actually be able to interpret its own ambiguous regulations? Whereas that's something the court should be doing. Mm-hmm. Okay, so that's going to have an effect. Foreign clients, especially my Japanese clients, have an issue with this because if you have a rule, they want to be able to follow the rule. But the rule is modified by so many things. So everything's enforceable. And then if the rule is overbroad, okay, then that has to be ruled on by the courts, and you can't have an overbroad rule. If you have a rule that's overly burdensome, like that's why they had to harmonize, then that's a legal court decision. But you're guaranteed everything under the Constitution. The Constitution says you have to have your day in court. So there's a certain due process that everybody has to follow. Now, I caution ex-U.S. manufacturers that it's very different because FDA can revoke your import license very quickly without that whole due process piece because you are not an American manufacturer.
Very important, very interesting point.
How the system works.
So, guys, we are running short on time, but let me ask you.
Naveen?
Yes, go ahead.
Naveen?
Go ahead, Ed.
If you can hear me, there's two questions I can answer right away. On MDSAP, that is going to be, the MDSAP documents are going to be revised to include the FDA regulations that are added. So MDSAP audit will have new information in it to cover what the FDA thing is. And what was the second one?
But that's an independent agency from. That's an independent piece.
It's independent,
So that's
but
right.
it's published on the FDA website. It's where the
It is published on the FDA website, but it's an independent audit procedure.
Absolutely.
So that's
but
why
that,
they
that's,
have to.
that's
why
how
they
it's
have to harmonize.
Yeah.
And that's why we were talking about that, saying they're going to need to harmonize that. Otherwise,
that's in
there would
process
be a
right now.
conflict.
That's in process.
Okay.
Also, one other thing that's important is the QSIT manual is going to be revised as well,
Yeah.
and that's in process
Yes,
too.
that's in process right now too.
Yeah, I've been involved with the FDA on all this, so that's how I can add this information.
Excellent.
So,
Excellent. Thank you
should help.
thank you for sharing
Okay,
that, Ed.
I'll shut up now.
No, thank you so much for sharing that. Guys, I know this is a very hot topic and interesting topic. We are running out of time, but I want to ask your opinion in the audience. Would you be interested in a slightly longer conversation at a different date? Please show me by thumbs up in the chat that you would be interested, and we will plan another conversation on this. I want to be respectful of everybody's time. And I want to give Neil just a couple of minutes to, just give us 2 or 3 key takeaways, compress these thoughts. And in the meantime, I'm going to share a couple of announcements with you. First, in a week from now, I will be doing a webinar. So the information is there on the Let's Talk Risk website. If you're interested in joining a webinar about software risk management, some challenges, practical tips, please take note of that and join if you would like to. Secondly, the recording of these conversations is available on the Let's Talk Risk website. So you can subscribe to the Let's Talk Risk newsletter. The link is there on this event page. And finally, most importantly, I say this all the time, all of you have unique insights and perspectives to share. So if you're interested in being a guest on this conversation, just please contact me and we will plan something out. We will put you in the schedule and have a conversation. It's very casual, informal, and no preparation required. We just connect 15 minutes before the live show and we go on. So I hope you will consider that. And if you're interested, just join me. With that, Neil, the floor is yours. If you can share just a couple of key quick points for us to remember.
The quick points to remember are these. It's a multi-layered system. So, as I mentioned, you have the act, you have the law, you have the regulation, which has the weight of law, and you have court decisions and things in the interpretation of this, FDA decisions, and Chevron is going to make a huge difference here. Secondly, they're phasing it in. And I know because I've been involved with the QSIT and they're changing the manual. One of our speakers also said they're changing the MD SAP regulations, and I expect all this to occur. But it will be an ongoing process, and we won't know exactly how it's going to play out until we get closer. That's why I recommend 90 days before or whatever you run parallel systems to make sure that you're covering everything that's additional to the current QSR in the QMSR. And the last thing I say is that in these legal matters, conflicts of law, things like that, Naveen had made a very good observation saying to have a quality plan. Have the quality plan reviewed by your quality consultant, an outside set of eyes, someone who works with this every day like Naveen, and then take it to your lawyer, because you can avoid a lot of problems by, taking it to your FDA lawyer and having him take a look at it and say, these points may be challenged in your plan by the FDA legally, or these are conflicting, or these are, and the big thing to be cautious of is don't exceed the regulations, because I don't know how many times I've had people call me. They've met all of the FDA regulations, but the problem becomes that they can't meet their own regulations.
The procedures.
And so they get an observation.
Yeah.
Exactly. Their own
procedures. Well said.
So I would say be cautious on that whole thing. But remember, this is evolving. And if we were to talk again 6 months from now, or whatever, all the way up until implementation, things would change. So make sure you're on top of the latest information.
Thank you, Neil. Thanks for those wonderful key points. Guys, as always, we are short on time, so I'm going to make it very quick. Thanks to everybody who participated, all of you for showing up. Special thanks to Chris, Ed, Bijan, and Christine for being a part of this conversation. And this is why it works. It works because we are engaged and we are participating together. And I've taken note of your interest in this topic, and we will consider this in a little bit more detail as time progresses and we learn more about this. So with that, guys, thank you very much again and have a good weekend ahead. We will see you once again next week. Take care, everyone. Bye-bye.
Thank you, Naveen.
Bye-bye.